Okay, can you hear me? Hi, everyone. I'm not sure if all of you know me, but my name is Holly Johnson, and I manage the Global Freedom of Expression database. And I am very happy to be here this afternoon, or almost this afternoon, with some old friends and colleagues. And the reason we thought we would do this particular panel is it's been 2 years since our last conference, as Professor Bollinger had noted. And we've done this now 4 times over the last 5 years. And we see it as a really important time for all of us to come together on a yearly basis to kind of review what's been going on in the world over the last year, discuss the trends, the interjurisdictional issues, and find new ways to collaborate. And since we haven't had time in the last 2 years to kind of get together, we thought we'd take some time now to hear from some of the active members in our community to talk about what they've been working on. The world has changed a lot in that time. Again, as Bollinger has noticed, we are now in an age of Trump, and strong men all over the world are putting new challenges to freedom of expression liberties. So I think what we'd like to do then is, use this as a rallying point to get all practitioners and academics together and to find a way of strengthening and continuing to build this community. What I'll do briefly is give everybody a little bit introduction, and then we'll kind of move down and hear about what they're all working on. And those of you in the audience who happen to be collaborating with them or are working on related issues, topics, I encourage you to pipe up and let us know what you're doing so that we can kind of use this as a platform for further discussions during the next 2 days. And I think what I'll do is I'll start with the way it is listed on the screen. We'll start with Q. So Q is the John Marshall First Amendment Chair Professor at the University of Oregon School of Journalism and Communication. Youm is a prolific contributor to scholarly debate on freedom of expression issues and is very widely published. His law journals on freedom of expression have been cited by U.S. and foreign courts, including the House of Lords in Great Britain, the High Court of Australia, the Supreme Court of Canada, and the Supreme Court of the Philippines. Next, we'll move on to the infamous Monroe Price, who hardly needs an introduction, but I will list a few of his many titles. Monroe is the director of the Center for Global Communication Studies at the Annenberg School for Communication at the University of Pennsylvania, and the Joseph and Sadie Danziger Professor of Law, and the director of the Howard M. Squadron Program in Law, Media, and Society at the Cardozo Law School, where he served as dean from 1982 to 1991. Professor Price is also an adjunct professor of communication at Annenberg School and directs the Stanhope Center for Communication Policy Research in London, as well as the chair for the Center for Media Communication Studies and the Central European University of Budapest. I don't know how you do it, but it is truly astounding. Then we'll move on to Karin, Deutsch, Karlekar. And Karin is currently the director of free expression programs at Penn and the American Center. And she served from 2001 to 2015 as the project director for Freedom House's Freedom of the Press Project, an annual report that tracks trends in global media freedoms. And then we'll move on to George. And George is the executive director of the Media Law Resource Center, and he was most recently counsel to the law firm of Jenner and Block. He is a former assistant general counsel of the New York Times Company, where he was at the forefront of numerous high-profile cases for the company and its affiliated businesses. He is also the William J. Brennan Visiting Professor at Columbia Journalism School, and he also teaches at New York University and CUNY's Graduate School of Journalism. Then we will move on to our own Jonathan McCully, who we share with MLDI. Jonathan is a senior legal officer at the Media Legal Defense Initiative and has been involved in cases before the European Court of Human Rights, the African Commission on Human and People's Rights, the ECOWAS Community Court of Justice, and the UN Working Group on Arbitrary Detention. He has also worked on cases before the domestic courts in Uganda, Singapore, and Tanzania. And he's also done quite a lot of legal training of lawyers around the world. He is our editor extraordinaire for the database, and also keeps us abreast of all the important cases coming down the line. And then we will move on to Sophia. And Sophia is a legal officer with us, and she is originally from Colombia, the country. But she also did get her LLM here last year, and she has formerly worked for Catalina Botero Moreno when she was the special rapporteur on freedom of expression, and has done quite a bit of work for Edson Lanza at the OAS, and we are thrilled to have her as our Latin America expert. So that's pretty much the lineup, and now we'll give everybody a few minutes to talk about what they've been doing over the last 2 years. Hugh, would you like to start?
Good morning. My presentation has a lot to do with what is going on in our institution, the University of Oregon, especially in the context of freedom of campus, and more specifically, freedom of student expression versus institutional right to speak. In the United States, if you're aware of what is going on, especially within the context of academic freedom, sometimes students are supposed to speak more. At the same time, sometimes students go beyond the reasonable amount of freedom of expression. I am talking about freedom to speak against the administration. And going beyond what is acceptable on and off campus is a lot more difficult to define. Now, when some people want to speak about something which is to be a little bit more sensitive, the fundamental question is what is sensitive enough? And that is why there are more confrontation between the administrators, I say school administrators, and the students. And in this particular case, at the University of Oregon, it has a lot to do with some students who wanted to challenge the right for the administrator to speak about what the administrators think should be very relevant to the university community. I am talking about President Michael Schill of the University of Oregon, a former dean of the University of Chicago Law School. He wanted to speak. He wanted to deliver his Union of the University speech to the UO community. But he was disrupted. Essentially, he was prevented from giving his Union of the University speech, largely because of the kind of heckler's veto situation. Some students simply took over the podium and prevented him from speaking about the Union of the University. Eventually, President Michael Schill delivered his speech, sort of a video, and still there was some kind of communication between President Schill and the UO community. He used the New York Times to give his own discussion, his side of the heckler's veto situation at the University of Oregon. He published an op-ed in the New York Times on October 23rd, and he strongly worded op-ed criticism of the heckler's veto response by some University of Oregon students was quite revealing. In many ways, it is a refreshing example of how the academic freedom is sometimes epitomized in terms of why school officials were simply shut out when it comes to students' exercise of what they think the community is right to know. This kind of background is relevant to why I am talking about the University of Oregon approach to freedom of expression on campus from a global perspective. I applaud the University of Oregon administration's approach to dealing with freedom of academic speech on campus from an international and global perspective. Generally speaking, as you might imagine, freedom of academic speech in the United States is more provincial, more or less parochial, in the context of the First Amendment to the U.S. Constitution. And even though we have to think about the relevance of the U.S. Constitution on the freedom of speech to the global community. Still, many of us in the United States think the First Amendment should dominate or predominate our discussion of freedom of speech and the freedom of the press as a human right. But that is a bit less relevant now than ever, as you probably know. But at least in the case of the University of Oregon, President Schill wanted to provide a rather unique, unusual forum for the UO community to discuss the global element of freedom of expression beyond the UO community. And that is why the UO International, UO Office of International Affairs participated in organizing this forum. Basically, the UO Office of International Affairs invited 5 panelists under the topic of global freedom of speech and internet expression. And 5 speakers were 3 international students from abroad and 2 foreign-born communication scholars, me included. 2 questions were primarily the main focus of the hour-long forum. How have you experienced the concept of freedom of speech and expression outside the United States? The second question is, how have you experienced the freedom of speech and expression during your time in the United States? The 3 students and also 2 faculty members at the University of Oregon were given a lot of freedom of expression, and they shared their first-person experience, not only in the United States, more important, outside the United States. And the audience was actively engaged to learn about the non-US experience with the freedom of expression. And also the audience learned a lot about that. There are a lot of, I can say, disparities between what we think should be freedom of expression in the United States versus what is freedom of expression outside the world. Especially international students, experience some kind of a chilling effect, even though the United States is supposed to be the, how can I say, robust, wide open, and uninhibited marketplace of ideas. Internationals come to the United States and they feel a lot more chilling experience, even though the U.S. is supposed to be open to whatever they think should speak out, but that is not the reality. And many American students and the faculty members were not aware of the kind of reality. Largely through this kind of open forum, they were given a rather unique opportunity to learn what kind of challenges in terms of freedom of speech and the freedom of the press, and also freedom of expression for international students was. And in my case, I was born in the United States. I came to the United States in 1980 as a graduate student. I am originally from South Korea, and in the 1960s and 1970s, South Korea was not the kind of country which South Korea is. South Korea now is more or less a vociferous, thriving democracy. But when I was a student in South Korea, I was more or less subject to all kind of harassment. I was kind of subjected to overnight, how can I say, army draft, sort of what, draft overnight, to learn a bit more Korean democracy 101. So tough life. But when I came to the United States in 1980, I came to the United States largely because, at least in 1980, America was definitely the land of freedom and opportunity, which I think, it should be, even today. But still, I think freedom of expression is more or less ups and down. And maybe freedom of expression is beautiful, largely because it is giving us never-ending challenges, largely because we have more challenges with the freedom of expression that is making us better appreciate freedom of expression. Maybe I might, stop here, then I move on to some questions from the audience or from the panel members.
Okay, sure. Does anybody have any particular questions for Q right now? Okay. Should we move on and then do some questions at the end? Okay, wonderful. So next on the agenda is Monroe.
Hi. Anyway, as I understand it, we're talking about specific areas that we're working on with our universities. And I think I've been specifically asked to say a few words about the Moot Court, International Moot Court competition, after which I was named, as it happens. That's a joke. In a way, organizing my thinking about this, I could say, how can we do something that's global, and how can we encourage young talent to be interested in issues of free expression and do so in a very rigorous way? So the most important thing is that this has been a collaborative effort that has involved many of the people in this room, and many of the people who would be in this room if they could be or would be. Andre Richter is here, Doreen Weisenhaus, Rebecca McKinnon, et cetera. Really, it's been a wonderful voyage with many different people. David Heller, I'm sure I can go on and on. But I'll say a few facts about this competition. This is the 11th year of the competition. It's at the University of Oxford. It's now housed in something called the Bonnevero Institute of Human Rights. It's led from this year forward by Kate O'Regan, who was on the Constitutional Court of South Africa and has recently moved to Oxford to take over this institute. It was run for the previous 10 years, and still involved is Nicole Stremlaw, who's at the University of Johannesburg, and as well as at Oxford. The Bonnevero Institute considers that it's there to integrate human rights research and practice within Oxford's law faculty and university more broadly. And the Moot Court works with the Institute to establish a vibrant community at Oxford engaged in pressing contemporary human rights issues around the world. So I think of the Moot as a global effort to encourage vigorous debate among law students on freedom of expression issues. I would say there are over 100 law schools around the world that are engaged in it. There are regional competitions in South Asia, China and East Asia, Africa, the Balkans, the Americas, and the Middle East. This year was the first year of an African round, sponsored in part by Google. I'd say there are two elements of Nicole Stremlaw's leadership I'd want to emphasize. One, and all these, I'd rather try to discuss some of the problems to make it a little more non-descriptive. One is how to make the Moot as inclusive as possible. This year, there were 2 teams from Iran at the finals in Oxford. There were 8 universities in Afghanistan that participated in the competition there. Bangladesh, Lebanon, Kenya, Egypt. This year, there was the first year of a team from Russia. All of these present really interesting issues. There are language issues, for example. How do you have a global competition on something like a Moot Court? Do you try to have it in many languages, or do you establish the universal, sort of temporary universalism of English? We've opted for the latter, although it poses great problems. And it's very interesting to see whether it's teams where English is the basic language prevail. India does extremely well in the competition, Singapore, et cetera, et cetera. How to attract and maintain teams from Turkey, from Russia, from, as I say, Iran. There are visa issues, there are language issues, there are political issues. How do you do it in a way that doesn't harm the students? How do you engage the institutions? China, for example, I feel proud of the fact that the Moot Court has a regional competition on freedom of expression kinds of issues with Renmin University in China. So that is I think, a very nice thing. The second aspect is what we call making sure the Moot is more than a Moot. I was just discussing with Guillermo the notion of partnerships that lead to training of judges in various places. How can the Moot be used as a way of encouraging training of judges? How does it deepen media studies in the universities involved? Chinmayi Arun is here. Chinmayi was the organizer of the first regional moot court competition in India, and out of that effort came the Center for Communications Governance, which Chinmayi has headed in recent years. And it's a really important example of how engagement with the moot and et cetera can lead to more intensive legal education on media issues in various places. And of course, it's a pleasure to work with our fearless leader, Agnes Karlekar, who's participated and spoken at some of our moot court competitions. The Iran team in Oxford asked us to help set up a system of distant coaches, of databases, of other things, and it'll be really interesting to see whether we can actually do something that implements efforts with people in Iran without a lot of funding and support. At any rate, there's a lot to be done in the future. I mentioned trying to get teams from Turkey and Cuba to participate, maybe get the Columbia Law School to participate. Maybe we're thinking of having Latin American rounds, Caribbean rounds, et cetera. So what I think is wonderful about it is, as I say, the collaboration, the effort, almost always totally voluntary by so many in this room and outside, and efforts that I think we all share in terms of building a kind of global community around these issues. I have a copy of our latest rounds, so thanks a lot.
And before we move on, I just wanted to share a couple of my experiences from the moot court. I had the honor of attending and observing a couple of years ago, and I was amazed by the talented people, the young students there. A lot of energy and a lot of passion. And we are not only a huge fan, but also a benefactor of the moot court, because many of our best and brightest young legal researchers. Beneficiary.
Right. I'd like you to be benefactors.
Benefactors, yeah, sorry. Yeah, we're working on that. That's the next phase. So they've come from this alumni program. And I got an email about 2 weeks ago from one of our researchers who just got back from the moot court. And I just want to read to you what he said. He said, "I have exciting news for you. My team reached the semifinals at Oxford University last week, and we finished third out of the 43 teams that made it to the world rounds. I also won a citation for being one of the top 10 oralists at the moot. I cherished every moment at Oxford, and the moot has, in fact, cemented my decision to continue working in the field of media law." So I think that's an amazing testament to the work you're doing.
We ghost wrote that letter.
Okay, we're not. Yeah, no. Monroe did not pay me to read that. Now, Q has done a lot of work with that as a judge. Perhaps Q can make a few comments about that experience and what that's meant for you, because there's always opportunities for many of you to go and take part in this as a judge.
I participated in one of the earlier moot court competitions at Oxford University. Probably one thing which is still very much striking about the moot court competition had a lot to do with some kind of interactions between the student participants and also the judges who were participating in the moot court competition. The interaction, I said dynamic interaction between the student participants and the judges is really enduring, I think. Because that kind of moot court competition gave the student participants a rare opportunity to know who was the best in the field and who could inspire them to go beyond winning or losing the competition. So that kind of enduring global impact should be a very important legacy of the moot court competition, beyond just winning and losing the competitions. And of course, already, the student letter, demonstrates that that kind of direct impact is going beyond the moot court competition. So in the context, the value and the impact and the contribution of moot court competition globally is absolutely immeasurable. That's what I can say.
Let me just say, sure. I've judged the moot court competition here in New York a number of years. And a few years ago, I judged the finals along with, on my panel, the actual chief judge of the Southern District of New York. And as we were preparing for the oral argument, she confided in me that she thought the facts in the case were more complicated than in any real case she's ever had. And I certainly concur with that. But more importantly, Monroe, I heard you say there might be a Caribbean section competition. And if it's St. Bartholomew's in January, I'm in. I just want you to know that.
Okay, well, why don't we move on to George? Would you like to tell us what you've been up to?
Sure. So I'm the executive director of the Media Law Resource Center based here in New York. It enables really communications among lawyers around the world to foster the values of freedom of the press and freedom of expression. We're a nonprofit membership organization. We count as members over 125 media companies from ABC to Vice, Vox, and Yahoo at the end of the alphabet. But basically all the, just about all the major newspaper, magazine, book publishing companies and broadcasters. And we're getting a lot of the tech companies as well, albeit Facebook doesn't consider itself a content company, so we don't have them yet, but we're working on it. And about over 200 law firms are our members also who work in the media law space. We put on conferences, as I'll describe. We distribute daily newsletter, a monthly law developments bulletin, a quarterly kind of law review, and an annual compendium of 50-state survey, libel law, privacy law, employment law. And we also have 18 substantive committees that are aimed at building a community of media lawyers who can work for reforms in media law globally. So these vehicles facilitate conversations on substantive issues to better share First Amendment values with colleagues across the world, and also let U.S. lawyers learn better what the problems and issues are elsewhere. So as a few examples of what we do, 3 years ago, 4 years ago now, we started a European media law conference in Paris. It really followed the Charlie Hebdo disaster by some 5 months. In our first meeting in Paris, we actually had armed guards because the keynote session was not surprisingly on hate speech. But the purpose of the European Media Law Conference is really both to organize European media lawyers to make them more cohesive and effective, and also to some degree to proselytize in favor of First Amendment values, because it became evident in the very first meeting that there's just a huger than expected divide on issues such as invasion of privacy, hate speech, et cetera, between the American lawyers and the European lawyers who were there. So how to bridge that divide, how to move slightly forward on the European side without being overbearing and, the kind of ugly American was one of the challenges that we had. This June, we're moving that conference to Berlin to get more German lawyers involved. And we'll have sessions on hate speech, on copyright, on right to be forgotten, and other top fake news and other current topics. Every 2 years, we have a huge conference in London, which really has 250 or so media lawyers, half from the U.S. and half from the rest of the world, including obviously the U.K. And the focus of that conference is really comparative media law, to look at all these media law issues from both a U.S. and European and rest of the world point of view and compare and contrast. Last session we had one on hate speech regulation, whether that was advisable, a panel of lawyers from countries where journalists are commonly in physical fear and under government censorship, a session where a hypothetical article was vetted from a U.S., a U.K., and EU point of view, and so on. So it's a wonderful conference, and it really, I think, establishes and succeeds at fulfilling our goal of bringing lawyers together, getting them to be more cohesive, and also to discussing, debating, and to some extent proselytizing for freedom of speech values. Last conference we have on an international basis is our Miami conference, which is focused on media, on Latin American media law, and we have that every spring. The last 2 years we've had sessions on reform in Cuba after Castro, copyright and trademark having to do with the Rio Olympics. We had a session just a few months ago on access and coverage of the hurricane in Puerto Rico, and on leaks in the Panama Papers. The conference, too, aims to make the Latin American bar more cohesive. I should point out that there was a discussion in our meeting last month that mentioned and actually talked in some detail about Colombia's free expression case law database and the use that lawyers globally can put to it. I should also point out that traditionally at this conference, American lawyers make suggestions to the Latin American lawyers about how to deal with their rather authoritarian, dictatorial, egomaniacal, press bashing, journalist attacking, free speech restricting leaders. At this past conference we had last month, the Latin American lawyers gave a lot of advice to us as to how to deal with our authoritarian, dictatorial, egomaniacal, press bashing, journalistic attacking, and speech restricting president. So kind of the cards were turned. We also file and participate in amicus briefs nationally. We actually find that our participation in amicus briefs is far more powerful in the international front than it is at home, and so we generally don't get involved as one of the usual suspects in amicus briefs here, but we do in important cases internationally. For example, we signed on to an amicus brief before the Court of Justice of the EU in Google v. CNL, opposing an outrageously broad reach of a French court order in a right to be forgotten case, and also joined a similar brief into the Supreme Court of Canada in a similar jurisdiction right to be forgotten case. At home, what we're doing now beyond our usual activities is we are joining with other groups, including PEN, including the Committee to Protect Journalists and the Reporters Committee for Freedom of the Press, in trying to develop really a social messaging advertising campaign to try to convince not the extreme right wing, but the kind of the middle of the road, heartland, red state voters of the importance of free speech, of the importance of free expression, try to push back some on all the blustering coming out of Washington. We're working on that now, and we hope to be on social social media platforms, and maybe even on television, probably after the midterm elections. But that's an important project that we're undertaking. Finally, just as an example of what we do, last week I happened to be in Jamaica on a trip that really was organized by one of Jamaica's leading investigative reporters, and it was really aimed at emboldening Jamaican reporters to be more aggressive, and also enabling Jamaican media lawyers to coordinate more effectively to seek some media law reform. I had meetings with the media bar, with students, journalist students, with reporters and editors, and the big event was a showing of the misnamed movie The Post, misnamed because as far as I know it was the Times, which first got the Pentagon Papers, vetted them, decided to publish them, and litigated the case all way before the Post did. My understanding is that Steven Spielberg is now working on a movie called Watergate, and its title will be The Times. But in any event, we had many of these meetings in Jamaica really aimed at some media law reform. I mean, Jamaica is pretty much on the English model, but you know, all these questions, their libel law is obviously not as robust as ours, and so all these questions were fair game, and it was an example of what we do to try to create reform and a better environment for freedom of expression all over the globe.
It's fascinating. I have a few questions for you, but I'll save them to the end. Does anybody in the audience have a question that they'd like to pose at this point? Should we move on? Oh, okay. All right. So Karin, would you like to move that? Yeah.
mic, everyone can hear me. Thank you so much, and I'm honored to be here on the panel, also adding to the gender diversity in terms of the participants on this particular panel. So thank you very much. And it's great to be back here among a great group of people again after 2 years. As many of you know, PEN America is a sort of unique organization in the free expression community. We stand at the intersection of literature and human rights to protect open expression both in the United States and around the world. And our free expression programs defend writers and the right to free expression through research and analysis, advocacy, individual case assistance, and then also partnerships with PEN centers in several countries. Just to reiterate what we've heard from President Bollinger already, over the past 2 years, we at PEN have seen a huge expansion of the threats to expression. And in response to this, PEN has also expanded its efforts, its staff, and its resources to combat these threats. Our free expression team, for example, has more than doubled in that time, if not tripled. I would say the only positive of these sort of expansion of threats is that I would say for many of our organizations that do work on these issues, we have seen increased interest and funding from donors as well. So that's been, I think, helpful in trying to combat some of these expanded threats in a number of countries and at home in the United States, obviously. I'll focus first a little bit and just give some highlights from some of our reports and research, which are conducted by several of my colleagues primarily. When I looked at our website, I was sort of astonished to see that over the past 2 years, we've put out 10 major research reports. What we try to do with our reports and analysis, I would say, is focus on really cutting edge and emerging issues in the realm of free expression. The majority of our reports are either on the US or China. I would say both countries, we focus on these two because both have major global impact, either in terms of setting standards, seeing where emerging trends are sort of developing, and then also, in the case of China, sort of the attempt to frame alternate standards on free expression and alternate modes of restricting expression. Of course, obviously, in the US, with all the declines that we've seen since the election of Trump, we feel a renewed impetus and priority to focus at home as well as our work abroad. So I'll highlight a little bit just of the project that we released last weekend. Actually, we launched over the weekend an online harassment field manual, which is a resource for writers and journalists who are defending against and countering online hate speech. The field manual was informed by a survey of more than 230 writers and journalists, and it revealed alarming evidence of a chilling effect in our online communities. 2/3 of the respondents reported having a severe impact of online harassment that has impacted their lives and their work, including fearing for their safety or the safety of their loved ones. Some have refrained from publishing their work, and some have permanently deleted their social media accounts and have just withdrawn from the space altogether. The manual is meant, however, to help writers stay online. So what we've tried to do with the manual is give information about establishing supportive cyber communities, engaging in counter-speech campaigns, enhancing cybersecurity, and also what to do when you have to turn to law enforcement. We also offer information to employers of writers or journalists about the best practices for supporting people to stay online. In terms of other areas of PEN's work, we have put out several reports on campus speech and also principles about how to sort of engage with campus speech issues, and a white paper on attempts to legislate at the state level campus speech laws in several states. We've also held convenings at 4 campuses around the country, which basically bring together students, professors, and administrators to discuss some of these very thorny free speech issues and what happens when free speech rights are conflicting with other rights and issues on campus. So that is sort of a major new area of our work that we have 1 or 2 staff people working on those projects. We've also put out a major report on fake news and also obviously sort of looking at the problem, looking at the various aspects, and also providing suggestions for how to tackle fake news. So again, although a lot of the focus of these reports has been on the US, they obviously have global applicability. Most of these issues are present to varying extents in a number of countries around the world. In terms of our reports on China, We've done several over the last few years. The most recent focused on government attempts to regulate social media. We also did a report on constraints on foreign journalists in China and how that helps to constrain the information ecosystem and the news getting out of China to the rest of the world. And then we also did a report on the disappeared booksellers in Hong Kong and the issues that raised regarding sort of rule of law issues and the sort of trend in China of kidnapping people sort of extraterritorially in Hong Kong and bringing them back to China as a method of sort of silencing critical voices such as Gui Minhai. So those are some of the highlights of our reporting and analysis over the last couple of years, and all of them are available on our website at pen.org. We've also launched in the last year and a half a new project called the Artists at Risk Connection, which really focuses on artistic expression and freedom. We're trying to build a network of organizations working on artistic expression and rights, and expanding the connections between the organizations that work in this space to better serve individual artists at risk. In terms of individual case assistance and advocacy, which is one of the sections of PEN's work that I had, our purpose here is really to help raise the voices of prominent writers, creative artists, and journalists on behalf of colleagues who are either facing imprisonment, legal cases, or other restrictions on their expression around the world. I'll highlight first one of our advocacy cases and campaigns over the last year, of Oleg Sentsov, who is an unjustly imprisoned film director and writer who's imprisoned in Russia. He's a writer, filmmaker from Ukraine. We gave him PEN's major award, the Freedom to Write Award, just about a year ago, and since then have been mounting a vigorous campaign on his behalf. My colleague Paulina, who's here, who handles our Eurasia programs, has been really pushing quite heavily on that case and bringing that to an international spotlight. It's particularly important in terms of this case being a very blatant violation of human rights related to the infringement of the territorial integrity of Ukraine within its internationally recognized borders. And the case itself contains a number of blatant violations of human rights and the rule of law, including torture, false testimony, and a number of issues. So Paulina's really been doing a lot of work on that case, which is, we're hoping he will get out of jail soon, but he did have a 20-year prison sentence. In terms of some of the other work, I've been working particularly on our advocacy and our center development work with Myanmar. We have a number of projects and work right now, basically working to build support for freedom of expression rights and principles among new members of parliament in Myanmar and among local communities. We're working a lot on legal reform issues, particularly on digital rights. We're working with partners next week. We are helping to support them to release a scorecard on free expression, which is basically a locally led attempt by almost 20 journalists and free expression groups in Myanmar to rate the efforts of the new government on free expression, and also to support a survey of journalists highlighting some of the main threats to press freedom and free expression in Myanmar. And then finally, I'm doing a lot of work recently on the case of the imprisoned Reuters journalists in Myanmar. So we are, I'd say on a range of issues and topics, we are trying to really push the envelope, create new linkages, get people out of jail, and really highlight a lot of the cutting-edge free expression issues that we're facing both in the US and around the world. So thank you very much, and it's all available on pen.org, or to talk to one of us. Thank you.
Does anyone have any specific questions for Karin at this point? Okay, we'll move on to Jonathan from MLDI. I know they've had a number of wonderful successes in recent months that we've been able to add to our database, but I'll let him give you the details, and maybe he can give some highlights of some things that might be coming down the pipeline that we should keep an eye out for.
Thank you very much. Can you hear me okay? Yeah. It's an honor to be on this very impressive panel. I feel like a bit of an imposter here. I'm from the Media Legal Defense Initiative, which is a non-governmental organization that's based in London, and we work around the world to provide legal support to journalists. And to do this, we work pretty collaboratively with a network of lawyers, NGOs, advisors, academics, many of whom are in the room today. and have been working with us in litigating on important free speech issues. So there are 4 main ways that we try to promote global protections for free speech. The first is a very simple means, and that is to ensure that journalists have a lawyer on the ground who is funded for them, who can run a case for them. So all cases that we work on will have a local lawyer who's working on those cases. Now, they're not normally a media lawyer, so often they have to work with us in developing their arguments and drafting their briefs. But we'll always have that kind of local collaborative element to our cases. We also take cases of strategic importance, so cases where we want to set a precedent that will promote and protect press freedom, either in a certain jurisdiction or regionally or across the globe. And I'll talk about one of the more recent judgments we've had in a few minutes. We also intervene in cases of strategic importance at international, regional, and domestic level. Last year, for example, we intervened 12 times at the European Court, but we also had interventions before apex courts in Uganda, Colombia, and we're about to intervene in a case in Canada that I'll discuss briefly as well. And finally, we train lawyers in several jurisdictions around the world. We're currently focusing on East, West, and Southern Africa. And the aim of this training is to skill up lawyers in media law. Like I said, in many countries around the world, they don't have media lawyers per se. We're quite fortunate in London and I guess in New York as well, where you can have lawyers who just specialize in that topic. So the aim of our training is to skill up lawyers so we can build a network of lawyers that we can tap into if journalists find themselves in legal trouble. So in terms of the kind of work we've been doing, 2017 was actually the busiest year we've ever had. I think we were working on over 80 cases ourselves directly in 52 countries around the world. And 96% of those cases were taken in countries that were rated partly free or not free in the Freedom House Press Freedom Index. A significant majority of the work that we're doing is pushing back on, challenging, or defending journalists against criminal laws that are used to kind of criminalize the work that they're doing. So criminal libel, sedition, false news laws. It's an old issue. It's been an issue that's been around for a very long time. These laws are incredibly old, but it's not going away, so it's important that we keep pushing on that area. And like I said, most of our cases look at that. Unfortunately, it's an incredibly long process. The lawyers in the room will know that in a number of jurisdictions we work in, it can take a very long time to actually obtain a judgment. And we've been working on some cases for over 7 years. For example, we've had cases on our docket for over 7 years. But in 2017, we saw a number of cases come to an end, and there have been a number of positive outcomes. We saw 8 journalists either released from prison or successfully defended against the imposition of a term of imprisonment. We saw 12 journalists successfully defended against the imposition of a fine or damages in relation to work that they've been carrying out. And we saw 5 media outlets successfully defended against state-imposed closure as well. So that's just an overview of the stats, if you like, for 2017. There's still an incredible amount of work to be doing. We don't always win, but it's always good to see that some courts are willing to build their press freedom jurisprudence and listen to the arguments we're trying to make. So I wanted to talk briefly about a recent judgment we obtained from the ECOWAS Community Court of Justice. So this is a regional court in West Africa. It's a human rights court. It's also an economic court. And we took a case there over 2 years ago on behalf of 4 journalists, as well as the Federation of African Journalists, who were representing basically the body of Gambian journalists who had been placed under a pretty repressive regime. They'd been subject to imprisonment, harassment, and some journalists had been tortured under President Jammeh's regime that recently came to an end in November 2016. So we took this case, we wanted to challenge the criminal laws that were being imposed on these journalists. That's criminal libel, sedition, and false news laws. We wanted to get a judgment from the court that would call for those laws to either be repealed or amended in line with international law. So that was kind of the objective we had in mind. We worked with 4 incredibly brave Gambian journalists who were living in exile: Alagi Jobe, Fatou Jolmane, Fatou Kamara, and Lamin Fati. It was incredibly brave for them to face up against the Gambian regime while it was under a dictatorship. And we also worked with the Federation of African Journalists, which is a pan-African body of journalists' unions, who were kind of taking an actio popularis on behalf of all Gambian journalists to challenge these laws and the measures that have been taken against journalists in the Gambia. So we obtained a judgment in February this year. It was actually Valentine's Day. It was a nice Valentine's Day present for us. And the ECOWAS court called on the Gambia to repeal and or amend their laws on criminal libel, sedition, and false news. They also found that there had been several violations of other human rights, like the right to live in your own country, freedom from torture, and freedom of movement as well. It's a good judgment. I would encourage you to read that judgment. It's also going to be an incredibly important precedent for the region. The court basically said that any laws that are criminalizing speech need to be really narrowly defined. And if it's protecting an interest like reputation, it's rarely, if ever, justifiable. We were also helped in this case by 8 free speech organizations who intervened. Also a Freedom from Torture NGO, Redress, intervened, and the UN Special Rapporteur, David Kay, also intervened in that case, providing really important and valuable international and comparative law input that helped the court reach the judgment that it did. I also wanted to talk briefly about some of the interventions that we are currently working on or that we have filed. Most of our interventions, like I said, are at the European Court, and at the moment we're trying to get the European Court to build its jurisprudence around the protections that are afforded to journalists when they're carrying out news gathering activity. We have seen in Europe and abroad increasingly the use of measures to prevent journalists from accessing certain areas. You might have heard the case in the UK of Grenfell, for example, where a council meeting, they tried to exclude
Jonathan,
journalists from that meeting.
Could you wrap it up?
Yeah, I'm nearly there. So we're currently intervening, trying to build jurisprudence on that, and there are a number of cases that I can talk to you if you want to come up to me individually, I can tell you about. Also, we have an intervention that we're working with PEN and MRC on in an incredibly important case in Canada that's worth following. Our filing is due next week. We're given leave to intervene. It's the case concerning Vice News, and it'll look at the protections that are afforded to journalistic sources in Canada. They may revisit the standards that are applied in such cases, and we're going to provide comparative and international law input in that case. Just a small plug, 23rd of May the hearing will be held, and it is televised, I believe, so feel free to tune in on that. And the final thing that I wanted to say was just the training in East, West, and Southern Africa. There are a number of those coming up again, and if you know any lawyers in those regions, I would encourage you to tell them about it. We'd be interested to receive applications from them. And usually it leads to concrete follow-up. We have several cases that are ongoing following our trainings. One, for example, where the closure of a newspaper in Tanzania is being challenged before a regional court, and challenges to various media laws in Tanzania as well before the same regional court. So it can be a useful way to actually spur on litigation as well through these activities. Thank you. Thanks.
Jonathan? Okay, next. We'd like to introduce Sophia Jaramillo, who's been working with us for the past year, and she's been working specifically on an educational tool that we've been developing, and she's going to give you some of the details on it.
Is this working? Yeah. Well, good afternoon. It will be just an announcement. I'll try to be very brief. At the Columbia Global Freedom of Expression, we're now designing a web portal to support and to strengthen the teaching and the training of global freedom of expression. This idea started after an expert meeting that we had in 2015 with law professors from all around the world. We got together and we discussed with them that they're engaged in delivering courses of global freedom of expression, comparative media law, and the objective of this meeting was to determine the state of affairs as far as courses on global freedom of expression, the adequacy of teaching materials, the obstacles and the opportunities that we have for delivering courses focusing on a global perspective for freedom of expression. This discussion concluded with the development of a plan of action to ensure that global freedom of expression is taught in a number of different law schools from around the world. The objective of this new project, of this new initiative that we have, is to design this web portal that will provide a range of teaching and training materials on global freedom of expression and media law, so that it can be literally a one-stop shop for curriculums, guides, training materials, multimedia resources, and so on. So that professors or people who want to teach freedom of expression can go to this portal and find out ways to adopt a global perspective on this issue. So obviously this project, we seek to promote the teaching of a global perspective on freedom of expression as opposed to a national or a regional approach or to just a comparative jurisprudential perspective. The goal is that students and the trainees are also informed and thought about the many commonalities that we have in the different jurisdictions. So that's what we're aiming to. On the second half of 2017, we began implementing this plan of action, and we started consulting with different stakeholders, and we initiated the design of this online portal. We started gathering all the tools, and we agreed on a partnership with the National Law University in India and with the University of Andes in Colombia. And we're reaching to a state that we need to design the structure of the portal and still finding different ways so that this could be accessible for professors and for teachers. Thank you.
Thank you, Sophia. Are there any questions from the audience at this point? Okay, Toby, and then Karuna.
Toby Mendel, Center for Law and Democracy. First, just a quick comment on the Moot. And I spent a little time working with the Afghan team. And I know when they went to the regional Moots, they kind of had their socks blown off by all of these incredibly eloquent people from India and Pakistan and whatever. So language, I think, is a really difficult issue. Like if you're not a native English speaker, it's really a big disadvantage. But I don't have a solution for that either. My question really is for Q. And you know that I have been following, to some extent, this case. And I have to say, I was really impressed that the president, I mean, if I was trying to deliver a State of the University address and the bloody students blocked me, I'd, throw them all in prison or something. But I mean, I thought he had a really mature and, I was impressed with his response, which was to foster a debate, about the issue. But I don't know kind of what the physical dynamics of it were, because I'm kind of struggling a little bit with that too, like how he didn't manage to prevail over them. But also, I'm also wondering whether you're not looking at something a little bit more muscular, because I mean, if I harken back to my student activist days, I could mobilize 10 or 15 people to disrupt practically anything. And, I mean, it wasn't, students are radical and they want to do things. And if we had been allowed to do that sort of thing in those days, we would have. And you can't have 10 or 15 students stopping discussions on campus, especially, that kind of thing, but any other kind of discussion. So, I mean, I wonder if you're not worried about, this thing getting legs and other students thinking, oh, we can disrupt things pretty easily, and, whether you have another solution as well.
When it comes to this kind of speech-related confrontation, especially in an institutional setting. Many students feel that they are structurally disadvantaged, largely because the university administrators have an always upper hand. But eventually, when we talk about who has a bit more right to speak, and at least the community, which has a right to know what is going on, not only from the student perspective, but also from the administrative perspective, that is where the dynamics is sometimes very, very unpredictable. And at least the University of Oregon is a still ongoing process. And actually, I say, Toby Mendel, you are coming to give a talk about the global issues relating to this particular issue, I think in late May. And so I say again, generally speaking, at least from my perspective, throughout human history, this is a reality. I think the more speech, the better. And no country has disappeared from the map of the world because they had too much history. Usually, because there is so little history, that is why many countries have disappeared from the world. Eventually, the more freedom of speech, the better likely we will thrive. That is reality we have to keep in mind. That's
Just to add on to that for a second, I mean, it seems so clear that nowhere is that more true than on campus. That's where students are supposed to learn and deal with different ideas, a diversity of viewpoints, not to be kind of narrowed and kind of cornered in believing in what they believe in and not listening to anyone else. So to me, for all the reasons you've just said, this issue is almost inexplicable on a campus where there should clearly be the greatest of uninhibited, robust, and wide open debate, because it's while students are forming their views and they ought to be exposed to all sorts. The notion of a kind of a sheltered existence from talk they don't like, I think, is totally inappropriate.
Same subject, actually. It's for Q and, everyone else, since everyone else has been thinking about the same issues, really. Just to introduce myself, I'm a litigator from India, the Supreme Court. I do a variety of civil liberties. I litigate a variety of civil liberties issues, including free speech, and also represent media companies. Now, as people who work on free speech, I think we have a visceral reaction to shutting anyone down, right? But I also increasingly think that as a global society, we're becoming more and more aware of the fact that more speech isn't necessarily the solution. So if you look, attention is a zero-sum commodity because of time, for example, right? And if you look at Facebook is the best example in terms of you may have more speech, it just may not be very accurate. You may have more speech, it may be a lot of hate speech. It may be hate speech that the ICTR, that the Rwandan tribunal found to be, that starts out at a fairly low level. It starts out calling people insects, right? That later then rises to a level of genocide. So I think that this sort of traditional idea that this sort of Oliver Wendell Holmes, the marketplace of idea, is something that's exploding now in market failure all over the world, not just online, in traditional media as well. And I do think that, I just read Penn's guidelines. I just skimmed through it. And I think it's an interesting start, but there are ideas, for example, of platforms. Does anyone have a right to a platform? Is the liberal analysis sufficient to address this kind of thing? Or, and dare I say the word in the United States of America, is a Marxist analysis of structural power useful in such a situation, so that we're looking at issues of power, we're looking at issues of who speaks, who doesn't, and we are looking at, and it's not just a sort of more speech is better and we're going to shut down the students, And I do think that this is actually a good place to reflect on those sorts of things. And so I would love to hear, I don't know how much time we have, maybe informally and formally from the panel, but also, others here who have thoughts.
Karin?
I have a quick comment just in response to that and to some of the other recent comments. First, a disclaimer, I'm definitely not an expert on this particular subtopic. A few of my colleagues really have worked in depth on our campus speech work. But just from what I've been able to take from many of their readouts of some of the sessions we've been holding on campuses, I think what we've found is that where the tensions really come in is where students feel like free speech rights are then conflicting and constricting their rights in other ways. So their rights as women to speak, or their rights as minorities, or other competing rights, and then where that comes into conflict with free speech rights. In the convenings we've done on campuses, where my colleagues have really found it was the hardest to pull people together to have these discussions, it was relatively easier, I think, at campuses where the main issues involved sort of controversial speakers and whether they should be able to speak or not. That was sort of, I would say, a less complicated discussion to have. But in cases where there had been, for example, actual incidents of racial violence, in one campus there had been a murder of a black student, those were the areas, the campuses where it was really, really hard to engage in this very absolutist free speech issue, or, and so that's what we found was in areas where there had been actual, much more serious incidents of, of violence, that was where we had the hardest time sort of convening people to discuss these issues and push sort of a free speech perspective. So it is something that I think that Penn is continuing to work on and grapple with. I don't think there's an easy answer. The report and recommendations we had were sort of a start, but we're trying to figure out sort of follow-on ways to keep engaging in this issue. But that's just an initial observation from what we've been doing so far on the campuses.
I mean, I can try. I think you raise very, very salient points. I do think it's important to distinguish what kind of speech we're talking about, because the notion of students stopping speech they don't like, positions they disfavor, the president of the university because he's a bad guy or whatever, I mean, that seems indefensible to me. On the other hand, I mean, we've had debates in a number of these conferences, as I think I mentioned, and I should shout out to David Heller, who's worked with me in organizing all these conferences. But we've had debates over the last couple of years about hate speech. And when you really are talking about bullying hate speech that's aimed at harming individuals or even small groups of people, I mean, that's a crime in most other countries of the world other than ours. And I don't think that we have the right, or, intellectually it makes sense to say they're wrong, we're right, let's just move on. I mean, I think they're really, really difficult issues if you're talking about, really scarring people with what you say about them, if it's aimed to harm them. It's not an easy answer. But that shouldn't be mixed up with, basically not letting a justice of the Supreme Court talk at your campus because you don't like what he has to say. Those are two very different issues. And the last thing I'd simply say is that on the other than narrowly defined hate speech, the other thing that's so troubling is false news. But I think for the most part, that's a phenomenon, for the most part, not wholly, of social media. And it seems to me it's not up to, it shouldn't be a matter of government regulation, which has lots of its own problems, as was discussed earlier, but is really up to the social media companies to monitor their platforms and somehow, in some responsible way, deal with it. But it's a very hard issue.
I'd like to ask a question of George as sort of a follow-on to this issue. If we kind of take these issues and put them into the red states, I'm fascinated that you're working with advocacy organizations to open up dialogue there. And I'd be curious to know what sort of framing of the freedom of the press arguments they're doing to reach a very ideologically rooted and driven community, and what is resonating with them at all as forms of counter speech or other sorts of access?
Well, I can't answer that in terms of the group we're working in, because we're really just kind of starting. But my own view, and this is a purely personal view, is that if you're really going to try to change people's minds, you clearly have to depoliticize it. It can't be about Trump or against Trump, because people are so ingrained in their views about Trump that you're going to turn them off in the first sentence. In terms of journalism and the importance of journalism, I've talked to a number of editors out there, and they all to an amazing amount of conformity, say the same thing, and that's that you have to emphasize local news, because people like their local newspapers, they like their local broadcaster, the local media has done good things for their community, and you have to start from that as the positive basis on which to move on, rather than deal with national issues which are so politicized already, and there's such division on that you're not going to be able to get much movement.
Are there any other questions from the audience? Okay, well then I'm going to call on a couple of people. I know there are some people in the audience who are working on some very interesting things, so I'd like to take a moment to introduce you to them, and then maybe have them stand up and just say a few words about what they're working on. We are very lucky this semester to have a visiting scholar with us by the name of Jacob Mishangama, who many of you may know. He's written quite a lot on free speech issues. Is Jacob here? He is now putting together a podcast on the history of freedom of expression. It's absolutely fascinating, and I'm hoping he can just say a few words about the program, and we'll give you the link to it so you'll have a chance to listen and spread it on to your students.
Thank you very much, Holly. Yes, it's a privilege every day to be sitting not in the same office, but very close to the Global Freedom of Expression Center. So the podcast is Clear and Present Danger, A History of Free Speech, which covers the history of free speech from antiquity to artificial intelligence once I get out of the Middle Ages. The idea is, the idea is basically that often I find discussions about free speech to be captive to tribalism or very sort of abstract notions, or being very legal in nature. So I wanted to try and say, you know, the historical context. Why are we even committed to this idea? Is it even important? What are the struggles that have defined free speech throughout the ages? And also sort of to learn from it, you know, what can the trial of Socrates, what can it teach us about the politicization of blasphemy laws? What can current debates about apostasy and blasphemy laws in the Islamic world, what can we learn from 9th and 10th century medieval Islam, where you had philosophers that had very, very interesting discussions about Greek philosophy that would probably get them killed or imprisoned in certain countries today. Academic freedom, what can we learn from debates between natural philosophers and theologians at the University of Paris in the 13th century, where you actually saw an explosion of reason and very interesting discussions. And when it comes to false news, what can we learn from the French Revolution, where quite a few people lost their heads because the revolutionaries went from praising free speech as absolute almost to suddenly, you know, killing people that they disagree with. I mean, even Tom Paine compromised. That says something about how difficult free speech is as a concept. So it's a fascinating journey. Like I said, I'm only in the Middle Ages. We're releasing an episode next Thursday, and then no, actually tomorrow, and then next time will be on the establishment of inquisitions in the Middle Ages. So we have quite some time to go before we get to all the tech issues that we deal with today. But even there, I think there are important lessons to learn for our very modern world from generations that have lived before us. So I hope you'll take the time to listen at one point.
Excellent, thank you. And I believe you've actually translated one of them, or have done that for Arabic, so
yeah,
it will be available to
sure,
other
like
countries?
the episode that we did on called The Caliphate on medieval Islam has been translated. The manuscript has now been translated, so we're finding an Arab speaker to actually narrate it and then try to work with an organization called Ideas Beyond Borders to spread it to the Middle East and North Africa. We already have listeners in Saudi Arabia and Kuwait and other places, Sudan, but we want to try and reach that area even more, because I think it's also important to have that non-Western elements of the history of free speech, because there have obviously been very important contributions outside the West.
Very much. And I'd now like to call on our Latin American colleagues, because I think Guy has been doing some amazing work in the last year, and Edson, we could maybe get some updates on what you guys have been doing. Do we have enough time? Yeah, we have 2 minutes.
Yeah, no. It's very, 2 minutes perhaps is too, need to be very synthetic, but what we are doing, expanding a program we started 5 years ago with many of you in this room about capacity building of judges in Latin America. So these last 2 years we reached the mark of 8,000 judges and prosecutors trained in the region in 21 countries. And perhaps the remark I would like to say is that when you saw people this morning showing the image of the senators or the congressmen and congresswomen interviewing Mark Zuckerberg and their difficulties in sometimes to understand the relationship of the technology with freedom of expression and privacy issues, when we are talking with judges in many countries, chief justices on an average age of 65, 70 years old, when we are explaining those kind of things, they have the same kind of questions. And so we need to even go further in this relationship with the judiciary and explaining to them all this new world, but also the general principles of freedom of expression already accepted by our country. So it's very exciting, very interesting developments, very concrete results, but many more things to do. I've mentioned we have trained 8,000 judges and prosecutors, but only Brazil has 17,000 judges. So still lots of people to be involved. And of course, we are doing this with Edison, with Catalina, and many others. Thanks.
Okay, I think it's time for lunch. Unfortunately, it's raining today. There is a magnificent patio out here, and we've set up tables, but go out at your own peril or bring your coat or, umbrella. Otherwise, we will be more or less confined to this room for lunch, so you'll have to just make the best of camping out inside today. But I think the weather's supposed to improve tomorrow. So you've got about an hour.